Hey there, this is Nick Zager and Remy is Daner. This is the Dentelligentsia Podcast. We have with us today DeLone Dawisha. He is a business attorney specializing in transactional commercial real estate. How's it going, DeLone? How are you?
I'm good, Nick. How are you?
We're doing great here. Just wanted to welcome you on. Obviously, we have this podcast really to help our clients and other business owners get high level information from uh, experts in their field. And we kind of, I mean, I've been watching from afar some of your informational content, which I think is absolutely awesome. I see it on LinkedIn and thought you'd be a great person to have on here. So just happy
I
to have you.
appreciate the opportunity to be here with both of you and to speak to your audience, and I'm really looking forward to this.
So I guess to start, you want to tell us a little bit about yourself, how you how you got into. I mean, right now you have your own firm.
Yeah, so I graduated from law school in 2018, and after that, I worked at a very large firm in downtown Detroit for 3 years called Honigman. Got a lot of good experience doing mergers and acquisitions work there. And then I decided to leave that firm and to start my own firm at the end of 2021. Dawisha Law. And at my firm, I specialize in three areas: business, real estate, and construction law. And I've had great opportunities working with a lot of different clients, and it's been an absolute blessing. And I always look to get my message out there and to just really educate people on different issues that can come up in these areas of the law, and to kind of just put that name out there and to build my brand. And I'm really happy to be here and looking forward to speaking with a lot of people who listen to your podcast.
Yeah, you're doing a really good job of it because Nick reached out to me some time ago and said we got to get this guy on
Sure.
Dentelligentsia. He's got you've got great content out there. You're doing a really good job. It's consistent, it's on brand, and so forth. So we're excited to have you on.
Thank you very much. I appreciate it.
So just to start off, we'll try to throw some easy questions at you. Do you have any favorite kind of client stories, or your favorite types of clients, or who do you like working with?
I have a very diverse client base. Pretty much anyone looking to start a business, buying or selling businesses or commercial real estate, or just leasing commercial real estate. I work with a lot of clients in those areas, and I have a few clients who develop, large scale commercial properties here in Michigan as well. So pretty much anywhere from people who are looking to start businesses, looking to buy or sell them, or just doing anything in the commercial real estate space. Those are my ideal clients that I work.
What you have? I mean, are there any specific like case studies or deals that are memorable that you want to kind of shout out?
Yeah, I mean, I really can't give any specifics on deals that I've worked on for clients in the past or that I'm working on now, but I've really worked on pretty much anything that you can imagine when it comes to mergers and acquisitions. I've had a lot of private equity clients, clients that are looking to buy companies in certain industries, and they buy those companies, add a lot of value, and then decide to sell them later on down the line. A lot of clients who do like ground up developments, for example, hotels, shopping centers, retail projects. All of those projects are really what I specialize in and what I've been able to work with for my clients. Yeah.
We are pretty similar. We have a pretty we like to help the small business owner
Hmm.
who who owns their when they're dentists, they own their practice, or if they own a different type of business, they from what we see, a lot of these folks, their preference, if they had a choice between being able to lease a space or buy a space, a lot of them would choose to buy something. But depending on the market or depending on what's happening at any given time, the market kind of dictates where the value is, and so that kind of helps to sometimes make that decision for them. But as someone who is working with these same folks, what is is there any big mistakes that you see these small business owners making that you would?
Yeah, absolutely. I mean, a lot of times when people start a business, they're kind of ignorant about like the things that they should be looking at from a legal perspective. So, they might sign contracts. A lot of times when you start up a business with a group of friends, for example, people really aren't looking to iron out the legal details from the beginning. They're just excited about a business concept that they have, and they're just really like focused on the product that they have, but they're not focused on the legal details. So they might start a company. They're not really clear on who's contributing what, who owns what percentage of the company, and what would happen if some sort of unforeseen event comes up, like, for example, the death of a partner, or if one partner wants out of the business. Those are the biggest mistakes that I see a lot of new business owners make. And then when something does inevitably come up, it really just comes down to how they choose to fix the issue or to deal with the issue. And my job as a business and startup attorney is to iron out those details from the beginning, so that way if something comes up in the future, you're able to handle it with the least amount of disruption to the business going forward. So that's one big area. Another big area too is when clients acquire properties or sign like leases with landlords for properties that they want. They're kind of not really educated on the legal issues that can come up in commercial real estate, the specific provisions that you would want to have as a tenant when you're negotiating a lease with a landlord, for example. What I always say is the devil's really in the details, and you want to know specifically what you're agreeing to. And a lot of times you want to negotiate for terms that would be favorable for your business going forward. And I always recommend that people work with a commercial real estate attorney before signing like an agreement to purchase a property or to lease a property.
You're the choir here, and DeLone, for the first PSA that you shared, it sounded like you were talking about an operating agreement. And is that the case? And you talk
like an operating agreement, with an LLC.
For those watching, can you just talk about why the importance of an operating agreement, which you touched on, and when would you need an operating agreement? When is that relevant to a deal?
Yeah, absolutely. So an operating agreement is not required under Michigan law, but especially when you're starting an LLC with multiple founders, multiple owners, you really do want to have an operating agreement in place, just because it pretty much spells out the different ways in which the company is going to be managed and operated, and it's going to spell out how profits and losses are going to be allocated to the different owners, and other things too. Like, for example, what happens when an unforeseen event comes up, kind of like what I was talking about previously.
Sure.
And it spells out like the ownership of the company as well. That's all in the operating agreement. And what I always tell people is you never know what's going to come up in the future when you're running a company. It's always better to be safe than sorry. And that's what I do, is I spell these terms out in the beginning. That way, when things do come up, we know how to handle it. We have a game plan going forward, and it's fair and equitable for all of the owners. That's what you want to have in an operating agreement.
That's for multiple owners. What about a single user, single operator?
Yeah, for a single member LLC, if you don't have an operating agreement, state law would control there. But I always recommend to still have an operating agreement in place, because it allows you to grow in the future, and it allows you to, when you add new owners in the future, you can amend the operating agreement and make it a multi-member LLC in the future. But at least you want to specify that you're the only owner of the company. You would put that on the exhibit of the operating agreement. And you would spell out some basic terms like, the name of the LLC, how it's going to be managed, whether it be member managed or manager managed, and some other details as well, some tax provisions and all of that good stuff. Yeah.
So we want one, regardless of whether you're on your own or you have partners who want one.
Correct. Absolutely.
Yeah. I mean, one of the big things that we come across, which we try to educate our clients, is that you want to have somebody who's an expert in negotiating purchase agreements, negotiating leases, because maybe you got a cousin, maybe you got an uncle who's a lawyer, but there's from our perspective, it's like we want somebody who knows what's market. Not somebody who's going to like bumble their way through a transaction, who lives in this space and does it day in and day out, because it might be cheaper on the front end using your cousin, but they might really not. It might be more costly down the road. Yeah.
Yeah, absolutely. 100%. I mean, you hit the nail on the head. What I would say is when people hear the word attorney, they right away they think, oh, this person went to law school. They can probably help me with whatever legal issue that I'm dealing with. But that's not really the case. I mean, I would compare it to a doctor, for example. If a person has an issue, they go to a doctor that specializes in that issue. It's the same with a lawyer. If you're dealing with a real estate issue, you want to go to a lawyer who specializes in real estate. And break it down even further. You'd want to go to a lawyer that specializes in commercial real estate if it's a commercial real estate issue, construction law if it's a construction law issue, and residential if it's a residential issue, because they all have their unique nuances. And you'd be at a disadvantage if you just went to a divorce attorney, for example, if you were dealing with a commercial real estate issue. You need someone that's savvy and someone that's done this, day in and day out, because it's like speaking a language. I mean, there's going to be things that you're going to have to deal with that only a commercial real estate or business law attorney would be able to help you with, right?
It's funny you say that. When people think about, I'm going to tease our professions here a bit. When people think about an attorney and how they went to law school, that the first thing they think about is that they're capable of taking care of their business. Because we are often having conversations where we are, adding some levity and saying, hey, we recognize there's a stigma when it comes to attorneys or real estate brokers and other professions too. And, we're and it's fair to some degree. People have been, had bad experiences, and so, and there, a lot of us suck at our jobs. Now we don't, and that's a part of why we're here, to talk about what we do and how we help people. But it's interesting that's a positive, a nice outlook. And I hope that people think about that when they think of us and the real estate profession as well. So,
yeah, absolutely.
Not to put you totally on the spot, because we didn't prep you at all for the types of questions that we were going to ask you, but it would be interesting to talk to you and get just off the cuff, get some of your feedback about some of the clauses that we see heavily negotiated inside of these types of agreements, especially leases. Leases are there's so much going on inside of there. And when a doctor or someone gets a 60-page lease, it's they read a few lines and they can see that the space is correct and that their name is correct, but pretty much after that it's all Greek. It's crazy. And so I wanted to talk to you specifically. I mean, like, really some of the main ones that we see people wanting to fight about are operating expenses, rent concessions, tenant improvements, and how there's reimbursements when the landlord is, giving TI dollars. The biggest one for us probably that we see is, the sublease and assignment clauses, because, dovetailing, I guess, into what you had talked about when you want to add somebody to the practice, or what happens when you want to sell the practice. And that's one that we find is like one of the last points to get flushed out and figured out before our clients are ready to sign.
Yeah,
let me know if there's any of those things you want to talk about them, but specifically, I mean, like sublease and assignment provisions are huge for us.
Yeah, we can touch on the assignment and sublease clause, and if you want, we can go through other ones too, one by one. But I mean, absolutely, those are very heavily negotiated provisions in commercial leases. And I kind of want to talk about it from both perspectives, from the landlord and from the tenant perspective. If you really have to put yourself in the shoes of the landlord. If you're leasing out a unit, for example, in your shopping center, or just a property that you have. You want to make sure that the tenant is a financially responsible tenant. You don't want to just lease this to anyone, because at the end of the day, it's your property. And if you have an issue with this tenant, you're going to have cash flow issues in the future as well. So landlords really put these anti-assignment clauses in their commercial leases because they don't want to be leasing to just about anyone. They want to make sure that it's a quality tenant that's not going to give them issues in the future. So what I oftentimes see is, the landlord will put a provision in there that says this lease may not be assigned by the tenant unless they receive the landlord's prior written consent. And oftentimes it's unqualified, and they don't even put which may not unreasonably be withheld, for example. That's the most landlord favorable way to make that kind of a provision. But a lot of times tenants who know what they're doing will come back and either remove that provision entirely and make it freely assignable, or state that the tenant can, assign the contract. Under Michigan law, contracts are freely assignable unless they state otherwise. Or, a middle ground would be to say, okay, fine, we won't, assign this lease unless we receive landlord's consent, but the landlord can't be unreasonable when we ask for their consent. And the question becomes, how do you define reasonable? And so what we oftentimes do is we say that the tenant has to provide proof that the proposed assignee is financially responsible, for example. You need to give 3 years of financial statements. You need to, prove that you can actually hold up your end of the bargain in the commercial lease that you're going to be assuming, essentially.
I mean, we've seen a lot of landlords would say, essentially that, hey, if you are assigning this to another entity or another person, and they have equal or greater financials, no problem. But what we run into is a situation where, if it's one doctor and they own or have owned this practice for 20 or 30 years, for example, and they want to assign it to an associate, well, that associate is probably strong compared to the general population, but they're not strong, compared to the main doc who's holding the lease. And so I don't know if you have any suggestions.
People are greater to financial strength, and therein lies the problem. I mean, Nick nailed it. That it's something that it's one of those provisions where we can't settle for a neutral or a neutral provision. It really needs to be in favor of the doctor, and it can be limited to, and we often seek to limit them to another doctor, for example, practicing the same type of medicine, dental in this case, but generally it's even that is not enough to provide that peace of mind and comfort, right?
Yeah, absolutely. And a lot of these commercial leases also have, get personal guarantees, for example, whether they be for just 1 year or for the term of the lease. And landlords are concerned that if they were to allow like an assignment, for example, they still have to get like an equal guarantee from the new person who's going to, the principal of the new assignee, essentially. So these are all different things that come into play. I mean, if a proposed assignee is not willing to provide a personal guarantee, whereas the landlord had it from the prior tenant, the original tenant, that's, arguably you could say that the landlord's not being unreasonable there if they withhold their consent to that assignment. So it can get very complicated. I've seen these provisions get negotiated in depth, but that's what really comes up.
In personal guarantees, that's a really good one to spend a little bit of time talking about, just because it's can be scary for somebody to do that. But if you buy a car, you buy a house, you take out student debt, that's what you're doing. You're signing a personal guarantee that you're going to pay this money back. The problem is that just a lot of these people that are our clients, they have hundreds of thousands of dollars worth of student debt potentially, and then they have hundreds of thousands of dollars worth of equipment debt, and or they bought a practice, or they're and so just next thing you know, there's millions of dollars, and so it's like really it's a really scary proposition. One way that we like to kind of at least pepper these landlords is try to say, hey, can we have a 1 year rolling guarantee, or a good guy guarantee that's limited to possession? Is there anything that you've seen recently that's interesting, or some interesting way where somebody was able to kind of meet somebody in the middle and figure out whether it was putting additional security deposit up or whatever the case may be, to kind of make ends meet in a situation like that?
Yeah, I mean, it's really what the parties are willing to agree to. I mean, it just depends on the economics of the deal. But a lot of times, like for a tenant, the biggest thing is just to try to reduce the term of that guarantee. You don't want it to run for the full term of the lease. I mean, if you're dealing with a 10-year lease, maybe you just limit it to 2 years or 3 years. That way, the landlord is like, it says, okay, I'm comfortable enough. I'll have recourse if this tenant is not able to meet their responsibilities for the first, couple of years of the lease. But if the tenant shows that they're able to make those payments for the first 3 years, in all likelihood this is going to be a good tenant going forward, and they're probably doing very well in business, and they're going to be able to pay the remainder of the lease over the term. So it's just what the parties are comfortable with. But from the landlord's perspective, they want to make the guarantee as long as possible, because if they ever did try to sell the property in the future, that's a good favorable selling point to say I have a full guarantee for the term of the lease. And
Well, not just sell it, but if they want to refinance it or anything, I mean there's more value that way. And so I mean, like our clients, of course we want to advocate for them, and nobody wants to do it, but the reality is that you're likely going to have a personal guarantee because your build out is so expensive, and what what the landlord contributed as far as TI dollars, construction time, and free rent is probably in the hundreds, and worth $200,000 to $300, or $200,000 to $300,000, not even including brokers' commissions and all this other stuff. And so it's a tough one, but any wins that we can get, we'll take.
Often, go ahead, Dylan.
Oh no, I was just saying absolutely 100%. I agree with you.
Yeah. Often advocating for our clients, in fact, it almost always does. Advocating for our clients includes setting expectations and sometimes having those difficult conversations. And the personal guarantee is one of those, can be one of those difficult conversations where we really are managing expectations of our client, because the idea of it on the face is almost insulting, and it is scary too. So, helping them understand how common it is, and that it's going to be in place, but that we're going to look to reduce the extent of it is a conversation we have all the time. So
yeah, and always look at it from the landlord's perspective too. I mean, if you don't have that personal guarantee in place, what's your recourse? You can only go after the LLC, and if the LLC, depending on what assets it has, if it doesn't really have much, I mean, the landlord is kind of out of luck at that point in time. You're going to have to rely on some very obscure legal theories to say, okay, maybe this LLC wasn't sufficiently capitalized, and we should be able to go after the principals. That's what you would really have as the landlord, and no landlord wants to be in that position. You kind of want to always meet people in the middle. You want to always work with people, hear both sides of the deal, and try to get people to the table to get a mutually beneficial deal. And that's really what I try to do in my practice all the
time. Let's talk a little bit about operating expenses. You see, I mean, right now, the majority of the work that I'm doing is on the tenant rep side or buyer side, but I have historically in my career been a landlord's rep, landlord's agent, and you see tenants wanting to fight and keep certain things outside of OpEx, and a lot of times, when you bring up, hey, let's think about both sides, a landlord can easily say, like, what's not controllable, or because the argument sometimes becomes, anything that's controllable, we want to cap at a certain percentage, but anything that's not controllable, for example, like real estate taxes or who knows what, that it wouldn't be capped, for example. And so I don't know if you have any anecdotes or dialogue on that topic, but love to hear it.
Yeah. Nick, so you're referring to, like, for example, common area maintenance expenses in your triple net lease. Is that what you're referring to?
Exactly.
Yeah, so let's break it down for the viewers just because they might not be familiar with what a triple net lease is. So a triple net lease, there's really two types. You can have just a regular triple net lease or an absolute triple net lease. A regular triple net lease would be a lease in which the tenant not only pays base rent, but also pays what's called additional rent. And that's defined in the lease, and it depends on how it's defined. Oftentimes, it includes taxes, insurance, and common area maintenance expenses. So let's say you're a dentist opening a practice in a shopping center, for example, and you're leasing out one of the units. It's 2,000 square feet. The shopping center is 10,000 square feet, just for example. Um, you're going to want to know what your proportionate share of the common area maintenance expenses would be. And for simple math, what we would normally do is we would take 2,000, divide that by 10,000, which would mean that you have a share of 20% of the shopping center's common area maintenance expenses. So every year, the landlord will bill you. Um, Usually, it's every month, so you get billed 12 times in 1 year, and you'd get billed 20% of whatever the common area maintenance expenses are. You get billed 20% of the property taxes and 20% of the insurance costs. And then at the end of the year, the landlord would do what's called a reconciliation to find out what the actual cost was. And then if there's, a discrepancy, you'd either be given a credit or you would be charged, whatever you still owe to the landlord. So that would be like a regular triple net lease. An absolute triple net lease would be a lease in which you're pretty much going to get charged every imaginable cost that's associated with the property. You would still pay your proportionate share, but it would include everything: capital expenditures. So, for example, if the landlord has to make a repair to the parking lot, you would pay for a portion of that. And it just comes down to what the parties are able to negotiate. But back to your question, Nick, the biggest amount of negotiation that I see is in what's actually defined as common area maintenance expenses. So, sometimes landlords will pass every cost to the tenant, like costs that pertain to the roof, costs that pertain to the parking lot, pretty much anything you can imagine when it comes to operating and maintaining the property itself. Sometimes tenants will try to negotiate like an annual cap in terms of how much it can go up per year. But there's really no right or wrong way to do it. It just comes down to what each party is willing and able to accept. And that's why I always recommend not only to work with an attorney, but to also have a commercial real estate broker represent you, because commercial real estate brokers really know what's market and what's not market, and they can add a lot of value there. And if you're leasing a property for 10, 15 years, whatever cost the landlord is passing on to you can really add up, and it can make a huge difference to your bottom line going forward. So you as the tenant want to have the most favorable terms for you and your business, and that's why I always recommend commercial real estate brokers. I've seen them add a lot of value for people as well.
The hardest one that I keep seeing over and over inside of the common area maintenance, is the landlord will tack on, some sort of like 15% surcharge for whatever their cost is to, maintain, maintain the cam, which is like, a lot of times it's a hard one that every time a tenant sees it, they want to puke. But
yeah, absolutely. And what I always recommend if I'm representing the tenant, include an audit right in the lease itself. Because if there's ever a situation where you think the landlord is passing costs onto you that they shouldn't be passing, or you just want to verify the costs, an audit right would allow you to do that. And oftentimes I see a provision in there. It's usually anywhere from 3 to 4%. They say if there's a discrepancy that's discovered of at least 3% or 4%, the landlord agrees to pay for the audit cost, the reasonable audit cost, and they would reimburse the tenant for that discrepancy. That's a fairly standard provision that I see a lot of tenants negotiate. And when I'm on the side of the tenant, representing the tenant, I always try to include that. I think it's a reasonable right to have, just to encourage transparency and to maintain a good relationship between the landlord and the tenant going forward.
That's a great tip. As far as audits go, who are you finding is typically who fronts the expense of those audits, and how often is a reasonable number in a given year or term?
In terms of how often is it reasonable to audit these
Yeah,
expenses?
is that typically going to be at the tenant's expense, and is there a limit to a reasonable limit to how often they can do that?
Yeah. So
Could be.
normally it's at the tenant's expense, unless they discover a discrepancy. And if it's a discrepancy that meets the threshold that's specified in the lease, then the landlord would be required to reimburse the tenant for that audit. Um, but I would say, once a year wouldn't be unreasonable. Oftentimes tenants don't invoke the right just because, if the landlord is being fair, being transparent, communicating costs to the tenant ahead of time, and even showing receipts for a lot of these things, I don't think a tenant would even be inclined to invoke that right. It really just comes up if a landlord, if it seems like a landlord is passing on costs that they shouldn't be passing on pursuant to the terms of the lease, or if the tenant just feels like some of the costs have gone significantly higher than what they were initially expecting, then the audit right would come into play. But it encourages transparency because a landlord, knowing that the tenant has the right to audit books and records and is able to get reimbursed if a discrepancy is found, the landlord would be less inclined to add certain costs to these expenses that they shouldn't be adding, to begin with.
What's a we see this a lot and a lot of times tenants don't understand what this clause is, but talk to us about a non-disturbance clause. What can you tell us about that?
Yeah, so you're referring to like non-disturbance, subordination, and a torment clause. Oftentimes, what that is it's very common in commercial leases, but what a tenant will include is called a non-disturbance clause, basically saying that if the property were to be foreclosed on, the lender would not, disrespect the right of the tenant to occupy that unit or that property, so long as they continue to make rental payments and they, honor the terms of the lease, essentially. Yeah.
Sometimes, from my experience, a lender won't even bother to look at that if a tenant isn't if a tenant is under a certain square footage, but it's a really hard thing to reconcile, because a dentist, for example, maybe they have 2,000 feet, maybe they have 5,000 feet, but they're still, it's not like a major tenant, like, how an office tenant could be in a big office park, for example. And so when they're putting that much money in, it's one of those types of things where, especially in this environment right now, where we don't really know what's happening, you may have a landlord who had a great, signed signed a great, have a great mortgage rate 10 years ago, and it's coming due, or it's coming due next year, and nobody really knows what's happening, or is the landlord going to be able to maintain the building, or the landlord. And so I just wanted to ask that, because it's, we're kind of in an interesting time where there's a lot of notes coming due, and a lot of uncertainty about certain types of property.
Yeah, no, I mean you see it in almost every single lease. I mean it's common to have those non-disturbance provisions in there. Another very common one as well is like an estoppel provision, and that they kind of go hand in hand a lot of times. But estoppel provisions basically say that you know if the property were to change hands, for example, a lot of times like the new buyer would require an estoppel, basically saying, okay, these are all of the terms of the lease. I'm not in default as a tenant, and people rely on those in order to close deals a lot of times. So um, when you're representing parties, you want to have that in place. You want to have a non-disturbance provision. You want to have an estoppel provision requiring the tenant to basically sign an estoppel certificate. If the landlord were to request that. And a lot of times tenants require landlords to sign that as well if they're looking to assign the lease to another party, because they don't want someone to come up in the future and say, oh, rent was still due when the landlord had received all of the rent prior to the assignment.
Or there was some side deal. Go ahead,
Can you
Remy.
just talk about the estoppel? What is it simply, and should tenants be apprehensive about signing them, because they're often presented with one and have no idea what it is, and if they should?
Yeah, absolutely. So if there is an estoppel provision in the lease and it says, upon request from the landlord, tenant needs to sign an estoppel certificate confirming certain facts with respect to the lease, um, they are technically contractually obligated to sign that. It doesn't mean that they need to sign off on something that's inaccurate or that's not correct. They just need to sign off on an estoppel certificate that confirms that the facts are true with respect to the lease. So what I always tell people is, make sure you read every word of that estoppel certificate before signing it. Understand exactly what you're signing off on, because sometimes parties might try to, sneak some sort of sentence in there that might not actually be true. For example, if the landlord is reviewing an estoppel certificate that the tenant wants the landlord to sign in connection with an assignment, it might say, tenant has made all rent payments that were required to be made and landlord acknowledges receipt of same. What if the tenant hasn't made, rent for the last 2 months, for example? The landlord wouldn't want to sign off on that unless and until the tenant came up to date with the rent. So estoppel certificates really just spell out certain facts with respect to the lease, and parties such as lenders or purchasers of the property might rely on that in connection with the closing. So that's really, from a very basic perspective, that's what an estoppel certificate is. And I always recommend just having a commercial real estate attorney review that before either the landlord or the tenant decides to sign it. That's my biggest word of advice.
That was my next question: is it advisable to have an attorney review it? And the answer is yes for anyone that's watching.
Yeah, right. Always have an attorney review any kind of agreement when it comes to commercial real estate, business, construction. You always need to have an attorney review that and make any necessary changes, because you're dealing with a lot of money, you're dealing with significant issues here, and you don't want to, have something come up that's going to cost you more in the long run. Whatever you spend on an attorney up front will save you a whole lot of headache and cost in the future, because you have someone who specializes in these issues, reviewing things and making changes that you might need to have before you sign off on it. Yeah.
So let's talk about commercial construction. I'm a tenant. I'm getting a healthy tenant improvement allowance from the landlord. In my case, I could actually have the landlord's contractor build out my space, or I could hire my own contractor. Let's talk about some of the pros and cons to each of those types of situations. Do you? If I were your client, how would you advise me?
So you said you can either choose to hire your own contractor, or who was the other party? I apologize.
Or use the landlord's contractor.
Yeah, it really just comes down to what your level of comfort is. I mean, oftentimes when I represent tenants, they want to be in control, and so they want to be able to, kind of set the rules, specify how they want things to be done. When you're dealing with construction projects, there's a lot of, issues that can come up in terms of cost. For example, you might expect your budget to be only $100,000, but the cost might go significantly higher. So I wouldn't necessarily say it's an issue when it comes to, whether you choose to use your own contractor or the owner's contractor. It just comes down to what the terms of the construction contract state. That's going to really be what's going to affect your bottom line. Whatever the construction contract states, how much it's going to cost, whether there's a cap to the cost of the construction project, or if like the contractor can justify certain changes to increase the cost beyond what was initially expected. Those are the biggest issues that I see come up in a lot of construction projects.
As a commercial tenant, if you're able to, if the landlord's contractor came up with a budget and the landlord said, I can do this project turnkey, and then the scope goes out of control, or the costs come out of control for some whatever reason, sometimes the landlord might have to eat that up. And also timing, when
Sure.
Like timing goes both ways. I mean, it's like nice to have your own contractor because they're working for you and you can trust, you want to trust that what they're telling you is real. But when the timing goes out of whack, that can be a big a big thing. And when it's the landlord's contractor, it's easier sometimes to kind of say, like, it was out of my hands. And so, but I mean, generally speaking, that doesn't happen very often. I think we would, for us, we prefer to have our clients interview multiple contractors and just get to know them, understand who they are, talk to them about some of the work that they've done that's similar, visit those spaces, for example, and then ask them what the hell happens. What happens if shit hits the fan? How do we deal with this? What's it going to be like? And you can get a sense whether you want. I think, if they do that and they go through that exercise with a couple of different contractors, they'll be able to have some level of comfort knowing, like, I want to go to war with this guy. I like him, and I trust him. And because, who knows what's going to happen? I mean, you always hope for the best, but I mean, these days you open up the wrong wall and, who knows what skeleton you're going to find and what additional costs are, a couple of years ago, it was like just the cost of materials just, jumped so much. It was happening so fast that it was hard for a contractor to even give an accurate budget. And so,
yeah, absolutely. Yeah, we're the times that we're living in with inflation being where it's at, and material costs kind of going through the roof. I would say out of all the different things that I've handled in my 6 years of practice as an attorney, construction projects are always where most of the issues can come up. I mean, project delays are very common. What do you do when there is a project delay? Is it an excusable delay or a non-excusable delay? And if it's not excusable, who's paying for that? Time is money. Time is always of the essence when it comes to these projects. And what I would just say as a construction attorney is, whether you're the tenant, the landlord, whether you're a property owner who's hiring a contractor to develop a project for you, you want to make sure you have a very robust construction contract that spells out every single term, and that really focuses on every single issue, even the most unforeseeable issues, because at the end of the day, we're living in unpredictable times and issues can and do come up. So you want to know what can happen. Okay, if a party is delaying the project, am I going to be compensated? Are there liquidated damages? Am I going to have some sort of recourse? So that way I can be compensated because I was told that the project would be completed within 12 months or a year and a half, but now it's 2 years out and nothing has happened yet. So you want to make sure you spell these terms out from the beginning, rather than have to deal with an issue later on and then hire some sort of litigation attorney who's going to cost an arm and a leg to try to litigate the issue for you. Yeah.
I mean, it's most of the time where problems arise, it's a break in communication somewhere in the chain, and somebody knew something and really it didn't get to the right person, or didn't get to them fast enough, or didn't get, or it wasn't told to them in a way where they recognized that, oh, this is going to be an issue. And I guess to compound that, I would say, well, when we're working with somebody, communicate, we have to be really strong communicators. We're helping these people gather a lot of data, on different properties, trying to figure out, is this, what's the best situation? Because when a dentist or a veterinarian or another doctor, when they decide to start up, go on their own, or potentially relocate an office or buy a building, those decisions are so expensive, like we were talking about. I mean, for example, the building might cost $200 a foot, and then it might cost $300 a foot, and then it might cost another $200 a foot for the construction, and then you got to buy all the furniture, and I mean, it just keeps on going and going and going. And so we want to hold their hand through that process and help them kind of create a nice decision-making matrix so that they can ultimately make the best decision for themselves at that time, because they're really in uncharted territory. I mean, there's so much unknown, and the risks are so big, they can't afford to make an uninformed or poor decision. do you see, I mean, I'm sure you see that a bit in your practice too. I mean,
Yeah, absolutely. I mean, at the end of the day, if you're a business owner, you want to work with people that are going to help you reach your end goal, right? That's what commercial real estate attorneys are for. That's what commercial brokers are for. People really need to shift their mindset from viewing these professionals as, merely a cost, because really they're going to help you and try to negotiate the most favorable terms for you, and try to help you get the best deal possible. And that's what I always recommend. I mean, I think people really need to shift their mindset and not look at professionals as just a cost, but rather as an asset and something that's going to help them moving forward. I try to be, there with my clients from the beginning of their business till the end, and I really have been able to see their businesses evolve over time, and grow over time. And you really need people like that in your corner helping you, to grow as a business, and to get the most favorable terms for you, in your commercial leases, in all of your projects. And that's what we're always here for. So
I appreciate you saying that, DeLone, because we, again, I think going back to managing expectations, one of the best ways to do that, to Nick's point now, is communicating early and often.
sure.
And when it comes time to building that initial team around our doctors, the attorney is one of those primary pieces of the puzzle. And I often find that my clients are price shopping, and ultimately their interest is to work with the attorney who's going to be the least expensive. And I'm it's an ongoing conversation where there are so many ways to save money in these projects. It's an important part of the process, that we are a part of, and at every level, really. Construction is another one. We're going to do everything we can to save money for our clients, but the one area where there just is no room for that is when they're hiring an attorney because of your specialization. And so, again, it's the best money they'll spend, and we remind them of that when we make those introductions to you, right? And the that peace of mind, that the impact and consequences of that money today is going to protect them for the next, if they're leasing, 10, 12, 15, 20 years. In the case of a purchase, indefinitely. So you can't put a price on that peace of mind, and it's the best money they'll spend.
Yeah, absolutely. And you really hit the issue perfectly, Remy. What I would say is, don't look at attorneys or commercial real estate brokers solely on the basis of cost alone. Cost is important. At the end of the day, you have to work with someone who's going to, fit within your budget, who's not going to cost you significantly more than what you're willing to spend. But I've seen a lot of issues come up where business owners choose, an attorney who's charging a very low rate, just because it's going to, reduce their overall cost for the project. But what I oftentimes say is, you don't know what the quality of that attorney's work is. You don't know if they're actually good at what they do. And just because they're signing off on agreements and saying, yeah, this is ready to sign, go ahead and sign it, doesn't mean that they actually did a proper job. And it might cost you more at the closing table. I've seen issues come up. I mean, I can get into some, small issues that I've seen in the past. It's one time I closed a project. I closed a shopping center sale, for example. I was representing the seller, and the buyer was represented from an attorney out of state. And this attorney brought some assumptions with him from his state that didn't apply in Michigan, with respect to tax prorations for the property. And he came into the deal thinking that taxes would be prorated in arrears rather than in advance. And he thought that his client should get some sort of credit in the closing statement. We were talking about a significant amount of money here. But after I informed him that, Michigan law was different from what he was expecting, his client had to, come out of pocket significantly on this property to reimburse my client for, property taxes on the closing of this property. And it really hurt his client because he, came into this deal with some assumptions that were not true here in Michigan, and it cost his client at the end of the day. And if his client, were smart enough to say, okay, maybe I should work with an attorney that's licensed in Michigan, that understands the nuances of Michigan law, this won't happen. But I mean, people have to learn the hard way sometimes, and it unfortunately happens more often than we would like to say. But you know, when you're working with an attorney, make sure that they're licensed in your jurisdiction. Make sure that they actually do the work that you need them to do, and that they're actually going to do a good job for you. Otherwise, it's going to cost you. And if you focus only on cost and how much per hour this attorney is charging me at the closing table, it's probably going to cost you more than if you would have just hired an attorney who charges more money than the other guy, but he knows what he's doing, and he's going to give you quality work, and he's going to save you from the headache in the future of having to deal with some sort of legal issue.
Yeah, that's a great example. I feel like in that, had that buyer been prepared and informed early and often about how much money that would cost, that and they still would have moved forward, but they wouldn't have had that disappointment, that frustration, that shock at the end of the process, right? Had they known. And that plays into the fact that setting those expectations and communicating early and often, is a great way to avoid a lot of problems that are completely avoidable. So
absolutely.
So getting back to you said you've been on your own practicing now for 3-4 years. How long?
Been practicing for 6 years total. Almost 3 years on my own, and I was 3 years at a very large firm prior to that. So time is flying by, really.
How did you decide, or what made you decide, like, I want to go and do my own thing?
So I come from a very entrepreneurial family and community, the Chaldean community here in Michigan. And so I've always wanted to have my own business. I've always wanted to own my own practice. So I had great experience working at Honigman. It's an amazing law firm. Still stay in touch with a lot of the partners that are still there today. They really made me into the attorney that I am, and I've learned a lot from them. But I just really wanted to be able to have my own business, to be able to run my own practice, and to have that relationship with my clients that I wasn't able to have as an associate at Honigman. You're just one, person on a team of attorneys, whereas now at my own law firm, I really just run the show, and everything that comes through the door, I'm, responsible for. So I was able to have that entrepreneurial route, having my own firm, but I love the practice of law and I still enjoy practicing it. So I kind of got the best of both worlds by doing this. Yeah.
What was the best advice you ever received, or how did you, how'd you come into real estate as a focus?
Yeah. When I started my own firm, like I said, I was mainly mergers and acquisitions and business law at Honigman, corporate law. But I noticed when I was going out on my own, I told myself, I need to expand into one additional area. I can't just only be an M&A attorney. And so I figured, real estate is the most logical, choice to expand into, just because there's a lot of overlap between commercial real estate law and mergers and acquisitions. Purchase agreements are structured very similarly. A lot of similar issues come up. You have to do your due diligence on the properties. And I just love commercial real estate in general. So I thought that this would be the best area for me to expand into. And I've always had an interest in real estate. And I believe that it's going to, give me a foundation in the future, should I choose to do anything else in the future as well. Yeah.
You got anything?
Nick, are you going to ask my favorite question, or should I?
You can ask your favorite question. I'm not going to ask it.
All right, DeLone. So, what would your parents describe what you do for a living?
I'm sorry. Who would describe what?
If your parents were asked what their son does for a living, or
Sure.
spouse, or children for that matter, someone important and close to you, what would they say you do for a living?
I think anyone would just say that I represent entrepreneurs and real estate owners in their legal issues here in Michigan and in their projects, and that I try to be a resource for them and an ally for them, and I really just try to serve them as best as I can to help them succeed in their practices and in their businesses. Yeah.
That's great. Well, it sounds like they're listening and they're paying attention, because I think if you ask my kids, my wife, my parents, you'd get 3 very different responses about what I do for a living. I still don't think that they they get it, and we have fun with it. But no, we that's a great answer, and we
yeah, certainly
we appreciate
my parents have no idea what I do, I think. Talk to us about if you could go back and talk to your 20-year-old self, would you have any specific advice for them?
Yeah, I mean, it's a great question. I would just say always stay persistent and stay patient, because patience pays and persistence is one of the key traits that I think most successful people have. I read the book Think and Grow Rich. It's one of my favorite books. And there's a section on persistence, and it really just talks about how a lot of people, how they persisted in life and how they continue to move forward despite criticism, despite obstacles and things in their way. If you stay persistent and you believe in what you're doing and you have faith in what you're doing, oftentimes what you want will show up and you'll be able to achieve what it is that you're after. And I would say from my perspective, having started my own firm, persistence is really what got me to this point. Leaving a big law firm like Honigman, a great law firm, and going out on my own and doing all of this organic business development and meeting with a bunch of different people, professionals, brokers, CPAs, business owners, and other attorneys. I really had to have faith in those early days, and to see that what I wanted would eventually come true. And I thank God every single day. Right now I'm at this point in my life where I have a very large volume of work from a lot of great clients. I've been able to work with so many great people, and I really am just optimistic about the future. And I feel like because I was persistent in the past, that's what got me to this point. And if I wasn't persistent, I probably would have just shut my firm down and went back to working at a big firm. But it's for me, I always believe in the principle of you cannot have a plan B. You have to always be focused on what your true goals are, and you have to stick to that no matter what happens. And that's what I've done, and that's what I'm going to continue to do going forward.
That's really cool. I would say for us, that taking initiative and being persistence is important, and in addition, it's being being consistent with that, always doing always doing the important things, even if they're hard, being consistently performing, so that it becomes ingrained and becomes almost like a habit, so that's really awesome to hear you say. Describe your perfect day. What would you do? Where would you who would you hang with? What would you eat?
Perfect day. I mean, normally I would wake up, answer a couple emails, do some couple of calls with clients. I think a perfect day for me would be closing a big deal, and then just seeing those months or sometimes even a year of just hard work and seeing the fruits of my labor, coming to fruition, and seeing the end goal. But I enjoy the process more than the end goal. I like what I do, but I would say my perfect day would be to close a deal and to see my clients succeed, because their success is ultimately my success as well. And I get a lot of joy out of helping my clients. So yeah.
All right. So last day on earth, what are you eating? I'm a food guy, so I need to know.
Sure. I've never been asked that question before. Probably tacos. I like tacos, so I'd probably have some authentic tacos. I'd love to go to Mexico. Some over there.
Any plugs for us here in the Detroit metro area?
So I haven't been able to find anywhere good here in Detroit, unfortunately, because I've traveled all over Latin America. So I guess I'm spoiled. I've been able to try the best of the best. But in Arizona, I've tried some really good places in Arizona. If you ever go to Arizona, there's a place called Taco Boys in Tempe. That's a very good place. And there's a food truck too. It's called Don Fito's. I've gone there in Arizona, and it's really good. But by far the best tacos I've had in all of my travels would be in Mexico. I've been able to try a lot of authentic places there, and it's one of my favorite foods. So
love it.
Yeah.
What do you have anything special that if the floor is yours, I guess right now, if you have anything that you want to say or any interesting initiatives that you got going on, or now's the time, I guess.
Yeah, no, I mean, Nick, when you had reached out, I really was happy because I've always thought about starting my own YouTube channel, and I want to really educate people, going forward on a lot of these issues that come up in business and real estate. So I am actually in the process of starting my own YouTube channel. So hopefully going to have that up and running soon so I can start making content and really educating people. So that's really in the works. And I'm just, doing what I've always been doing, running my firm, building and meeting with as many people as I can. If anyone's ever interested in meeting for coffee here in the Metro Detroit area, they're more than welcome to reach out to me. I always love meeting new people and really just getting my name out there and seeing if I can work out, synergies with different people and how we can all help one another. So if you'd want to, maybe leave my contact information in the description of the video, I'm more than happy to provide that to you. And, looking forward to seeing the video online. And it was really a great opportunity. I'm very grateful that you invited me here to speak to your audience.
Well, you were really informative. Maybe, hopefully, we didn't get too deep into the weeds for some people who aren't, jiving on commercial lease lingo day in and day out. But it was cool to be able to do it with you and get some advice and guidance. And it's really cool to see what you've built. And we will definitely have to take you up on that and get all of your social media info so that we can put it on this video and keep on keeping on and serving your clients at a high level. We love it. Love to see it.
Yeah, absolutely. Thank you, Nick. Thank you, Remy. It was really a pleasure to be here, and I'm very grateful that you invited me to speak to your audience.
Likewise, we were happy to have you.
Thank you.
All right.